Okay, so we have four motions that are up for hearing. We have Ms. Citadel Jones's petition for rule to show cause, which she filed on May 5, 2022. And we have a second petition for rule to show cause that Ms. Jones filed on July 1. And then we have Mr. Jones filed a motion regarding the former residence and a motion to modify parenting time and increase unsupervised parenting time. Those are the four motions that are up for hearing today. Is that right, Mr. Esser?
That is correct.
Ms. Jones, that's correct?
Your Honor, the latest, I believe they filed a motion last Friday, September 4th, and it's not up for hearing today because Attorney Esser told me that I have at least 21 days to respond to that. The last motion for unsupervised visit. It's not part of the hearing today, Your Honor, right?
No. There's a new motion to modify parental responsibilities and to appoint a custody evaluator, which was filed on September 2nd. That motion is not up for hearing today.
Okay, thank you, Your Honor.
There was a motion that was filed weeks, if not months ago, where Mr. Jones was asking to increase his unsupervised parenting time from the current 3.5 hours to 5 hours. That is up today. All right, so we'll take these one at a time. First, we have Ms. Jones's petition for rule to show cause filed on May 5 of 2022, where she is claiming that Mr. Jones is refusing to sell the Kawasaki motorcycle that the parties owned together. And she's indicating that the judgment for dissolution requires that the parties shall immediately sell the Kawasaki motorcycle. And since that's not happening, she wants me to order that she has possession of that motorcycle so she can sell it. So that is the petition that Ms. Jones has filed. So before we begin a hearing on that petition, let me ask you, Mr. Esser, does your client oppose the court order that Ms. Jones is asking me to issue, where she wants me to order Mr. Jones to turn over possession of that motorcycle to her so that she can sell it? Does your client oppose that?
Well, we oppose that order, Your Honor. We don't. Were you asking, do we oppose? We oppose the entry of an order giving her possession to sell it.
Okay, that's fine.
I just want to make sure that we all understand the motorcycle needs to be sold.
Jones, can you hear me? You have an attorney, which means your attorney speaks for you.
So I can elaborate, Your Honor. I didn't know if you wanted me to elaborate or not. The issue is Mr. Jones has possession of the motorcycle. Ms. Jones has possession of the title. Ms. Jones and I have been talking for months about how can we compromise. The problem is that every time Mr. Jones has a prospective buyer, we have to let them know that we don't have the title. And so the offers that we're getting are pretty low. I told Mr. Jones, just take the next offer that he got. So he has an offer.
Hold on a second. Mr. Jones, you hired Mr. Esser to represent you, is that right? Okay, this is what we're gonna do. Because I'm already losing my patience and we're only on motion 1 of 4. Knock it off, Mr. Jones. I don't want you nodding. I don't want you making faces. I don't want you saying anything. You hired an attorney to represent you, so he's going to represent you. Do you understand? Mr. Jones, unmute yourself. Is Mr. Esser representing you, or is he not? He's either going to represent you during this hearing, at which time you will not speak unless I ask you a question, or he's not. That is a decision that you have to make. Make it now. Guess what? Is he representing you or is he not? Now, I don't know what the problem is with the communication between you and your client, Mr. Esser. If you need some time to talk to him, I'll do that. But apparently he's acknowledged that you are representing him, which means you are going to continue speaking and he's not. Do you need to talk to him before we continue?
No, I'm sure that I know exactly the situation, Your Honor. So,
Continue.
okay, so Mr. Jones has a sales contract to sell the bike. What the issue is now, so Ms. Jones's motion is a couple months old. Situation has changed. Now Ms. Jones is saying that the price that Mr. Jones is going to sell the bike for is too low. The problem again is that he can't sell the bike without the title. So we were hoping to find a compromise because the order is clear that this bike is to be sold. Thank you.
Okay, Ms. Jones, what's your response?
For my response, Your Honor, it is indeed true. I have been making communication with Attorney Esser, and every time I'm trying to be cooperative with a compromise, and their excuse was, I have to sign over the title to Mr. Jones right away so they can sell it. And my response to them is, why do I have to sign it right away without a buyer? Because they wanted me to sign over the title to him right away. And I said, I'm willing to compromise that every time there's a buyer, I sent them the picture of the title to show it to the buyer, and I will meet them anywhere where there is the buyer to prove that I'm willing to cooperate in every step of the way to sell the motorcycle. But they refused my offer of that. All they wanted me to do is just sign over the title. And I told them, why, once I sign over the title to the name of Jason Jones, he's not the buyer, then that means he owns it. And I said, and I've been reaching out to them, and it's not true that I'm not willing to compromise. I have been trying to compromise. I have email exchanges, but it was Mr. Jones who's making it difficult to come into agreement. All they wanted to do is for me, give them the title, and that's a compromise they want. So they're leaving me with no choice for me to just sell it myself with them present. I'm willing to sell it with their cooperation, but apparently last Monday, Your Honor, I received an email from Mr. Esser that Jason Jones already sold the motorcycle for below the market price, $750, without letting me know. So for myself, Your Honor, all this is not uncooperative of the other party.
Ms. Jones, you currently possess the title to the Kawasaki motorcycle, is that right?
Yes, Your Honor, because I bought it during the marriage.
Whose name is the title in, yours or his or both?
Mine, Your Honor, because I bought it.
Okay, fine, thank you. Mr. Esser, anything else?
Well, if Your Honor would indulge my client to speak, I think he wants to say something.
I suppose I can take it by way of testimony. Mr. Esser, raise your right hand. I'm sorry, Mr. Jones, raise your right hand. And Ms. Jones, raise your right hand also. Do you both swear to tell the truth, the whole truth, and nothing but the truth, so help you God, as each one of these 4 hearings progress today? Mr. Jones? Ms. Jones?
Yes, Your Honor.
All right, you can put your hands down. Mr. Jones, go ahead. And what's the amount that this person agreed to pay for the vehicle, Mr. Jones? $750. And the agreement between the two of you in the judgment order indicates that the parties shall immediately sell the Kawasaki motorcycle for its fair market value. The proceeds of this sale shall be deposited into attorney Shama Parik's client trust fund. One half of the proceeds shall be directed to the GAL, who is owed $12,000 in fees, and the remaining half shall be divided equally between the petitioner and the respondent. So what is it that you believe the fair market value is of the motorcycle, Mr. Jones? What do you believe the fair market value is with the title? Ms. Citadel Jones, what is it that you believe the fair market value of the vehicle is?
Your Honor, during the hearing, when we were still talking about it under Judge Christensen, my lawyer, Shama Parik, showed to Judge Christensen the fair market value from Kelly Blue Book, and Mr. Jason Jones was present there with his lawyer. And because Judge Christensen asked for the fair market value, it's market value $6,900 on what she showed. And other than that, on that hearing, I also showed to Attorney Esser that the market value of the motorcycle is over $6,000, and I'm even settling with $6,000 so we can split $3,000 each, 50%, and my share would go directly to the GAL. That's what I said. It's not even going to me. I told this to Attorney Esser. I don't know what happened.
What year is the motorcycle, Ms. Jones?
2016 ZX14 Ninja Sport motorcycle.
Okay. Mr. Esser, is there anything else that you want to say by way of argument?
By way of argument, I would just like to point out that the talks between me and Ms. Jones, it wasn't exactly what we were saying. It's just sign over the title. I was saying that the title could be placed at my law office, and until there was a sale, then I would hold on to the title, and then any buyer could communicate directly with me regarding the existence of this title and whether or not it would be signed over. So I still think that's a fair compromise. Well, it's already sold now, but—
A minute. Mr.
Yes.
Jones, I permitted you to speak by way of testimony. Don't say another word unless I tell you to speak for the remainder of this hearing. If you do say another word and speak out of turn, it'll be the last thing you say. Tell me you understand. Wonderful. So we'll put you on mute. If I need to unmute you, I will. You finish what you were saying, Mr. Esser?
Yeah, I was just going to say, Your Honor, that this case is pretty contested. There's a lot of distrust between the parties. I'm happy to facilitate whatever the court would like so that this motorcycle can be sold appropriately. But yes, if the situation with the title exists, I think that Mr. Jones is right. Who's going to buy a bike without getting to see the title and knowing whether or not the parties actually own this bike? And so the fair market value would be drastically less than what it would go for otherwise. Thank you.
Okay, thank you. Hang on 1 second for me. Okay, the next motion that we have is a motion that was filed on Mr. Jones' behalf regarding the party's former residence. Mr. Esther, that's your motion, so you may argue.
Okay, thank you, Your Honor. Party's former residence is currently being occupied by Ms. Jones. The parties were under foreclosure at the time that the judgment was entered in March of 21. Also at that time, there was the state of Illinois had a stay against mortgage foreclosure proceedings. The judgment says that once that stay by the state of Illinois is lifted, Citadel has 180 days to make attempts to refinance the mortgage. If she's unable to do so, then Jason gets a turn. And if Jason's able to do so, then he would take possession. The reason for this motion, so let me just back up. Citadel has not only not refinanced the mortgage within those 180 days that she was allotted, she's also filed for bankruptcy and has all of her liability completely discharged with relation to this mortgage. So it would be impossible at this point for her to exercise her right under the judgment. Mr. Jones, at the time of this motion, back in late May, early June, has been making attempts to refinance the mortgage. The question came up with the attorney who's handling that mortgage modification, is whether or not Ms. Jones would vacate should Jason actually be successful in his efforts. Ms. Jones has indicated to me that she does not want to vacate and that she wants to remain in the residence. And so that's the purpose for this motion, is just to clarify that Ms. Jones would need to vacate and Mr. Jones would get possession.
Okay, Ms. Jones, your response?
My response, Your Honor, is the attorney for the house that I have been speaking to, even after the divorce decree of March 17 by Judge Christensen, I notified Penny Mac already and the lawyer. I have been in constant communication with attorney Ryan Sawyer, and in truth, they will be visiting the house for, I don't know what you call it, for pricing for the house on September 30, because my forbearance will end on September 30, 2022, and I've already started the process of loan modification, and they have been taking care of my paperwork, because after the divorce, I told them before I filed for bankruptcy that I will need to file for bankruptcy, but I would like to save the house with the help of attorney Laura Fry on my bankruptcy to notify the Penny Mac. So I did. And I've always in constant communication. They put me in forbearance with regards to my hardship, with the divorce and the hardship on money. And I said, I'm keeping my job, and I have a son in the Army for 4 years now who is going to help me, and they will add his name for the VA military loan. So they're in help with me. And actually yesterday, Your Honor, they updated me that they have been sending other paperwork for my son in the military to fill out, so they can modify everything for me before the modification is up. They put me in forbearance, Your Honor, because Judge Christensen said there to have an agreement in work with Penny Mac, with the mortgagee, and I did my best to work with them. It was Penny Mac who put me in forbearance, Your Honor, to give me time to have a bearing before we start the process of modification, to give me time with all this. I've been honest with them with my situation. I told them before I filed for bankruptcy, and after I filed for bankruptcy, I gave them the record, and I have been in constant communication with them. It's up to you, Your Honor, because this is the only stable thing that I can give to my 2 minor children who are attending Woodland School. They love the neighbors. The neighbors' kids are coming into my house on the weekends or sleepovers and study time. And if they're going to vacate me of this place by Mr. Jones, where is the stability that I'm trying to put up to my children? It's not true, Your Honor, that I've been neglectful of this thing. It was very hard for me that the house went on to foreclosure, because when we started the divorce, everything was hard. but I tried my very best to keep in constant communication with PennyMac, and it can be verified with them that I'm in constant check-in with them. Attorney Sawyer has spoken to me September 2 and September 3, and we have arranged for PennyMac to come over on September 30, and everything can be verified, Your Honor. So if I don't know, Your Honor, at this point, why they wanted to take possession of the house just because they think I did not refinance it right away, even before the governor's decree order expired on October 17. October 1st, I was approved by PennyMac already, Your Honor, for forbearance. So I did my best even before the time lapses of the governor of decree in Illinois. I don't know what else I could do, Your Honor, to do my very best to try to comply with everything. I called PennyMac, I called their lawyer, I'm in constant communication. So it's up to you, Your Honor, if I may be lacking of something, but yes, I am in loan modification right now in process.
Okay, Mr. Esser, any reply?
My reply to that, Your Honor, would be that number one, the judgment only gave her 180 days from last October. And that number two, Ms. Jones filed for bankruptcy. She will have no ability at this point to modify that loan because it wasn't a Chapter 13, it was a Chapter 7, as Your Honor sees in the attachments. And that she didn't do anything to redeem that mortgage in the bankruptcy proceeding. So she has essentially washed her hands of this mortgage at this point. And then finally, the last thing is that there is no petition on file to modify the divorce judgment to give Ms. Jones more time. This is just a motion to enforce the existing judgment as it is. And without anything else before you, I think Your Honor's hands are basically tied that the prior judgment has to stand.
And what is it, Mr. Esser, exactly that you're asking me to order?
Well, Mr. Jones, he doesn't quite have his mortgage modification worked out. They're still in negotiations, unless you have an update for the court, Jason. But the order would be that as soon as Mr. Jones can modify that mortgage, that he would then get possession of the house.
Okay. Mr. Jones, you can unmute yourself. Okay. I don't need to hear anything else regarding that particular petition. Let's move on to the next one, which is Mr. Jones's petition to modify parenting time and ask for additional unsupervised parenting time. This is the petition, Mr. Esser, where you're asking for Mr. Jones's current 3.5 unsupervised hours a week to jump up to 5 unsupervised hours a week. Is that correct?
So it's actually 3.5 hours supervised that we'd be asking for that to turn into unsupervised.
When I looked at your motion, maybe I'm misremembering it. Let's see.
And I'm pulling it up too right now. He currently has two aspects to his visitation, Your Honor. He can take the children unsupervised to church on Sundays, and then if he has supervision, he can have an additional few hours after church.
Right. You're asking for what?
We're asking for those hours after church to become unsupervised according to the recommendation of the reunification therapist.
And the recommendation of the reunification therapist pursuant to that letter that you attached to this petition was
that Mr. Jones be permitted 5 hours of weekly unsupervised time with the children.
right.
So it wouldn't include overnights at this point. You know, we're working up to that. And in fact, we have a motion on file asking for even more than that at this point. But that's
My
where
question, Mr. Esser, the question, Mr. Esser, is currently the allocation judgment presumably allows your client to have unsupervised parenting time on Sundays from 9:30 a.m. until 1 p.m. in order to take the children to church. Is that correct?
That's correct.
Just 3.5 hours, correct?
Correct. Yes, then correct.
Now, the letter from Dr. I don't know.
Yorgi. I think it's
Yorgi.
Swedish.
Right. The letter from Dr. Bjorgi says, quote, "It is advised that Mr. Jones be permitted 5 hours of weekly unsupervised visits with his children. This extended time will allow enough time for a couple of activities like dinner and a movie." Now, Dr. Bjorgi does not say directly that 5 hours is meant to be in addition to the current 3.5 hours of church time, nor does well, basically my point is the doctor doesn't seem to clarify whether it should be a total of 5 hours of weekly unsupervised visits with his children in addition to the 3.5 hours of church time or instead of the 3.5 hours of church time. So what do you want to say about that, Mr. Esser?
Well, what I want to say about that, I was not the attorney at the final judgment, Your Honor, for the trial. But I believe that the spirit of that order is that taking the children to church is a public place with other people around. You know, there would be, no opportunity for harm. So that's, kind of a supervision, if you will. So what we would be asking is that in addition to allowing him to take the children to church on Sunday mornings, that he would then have 5 hours that wouldn't necessarily have to be on Sunday because the children do have activities, but it could be, a 5-hour period unsupervised at some other point during the week.
Okay. Ms. Citadel Jones, what do you want to say?
Yes, thank you, Your Honor. In addition to that, for their petition, right after the divorce on March 17, Your Honor, there has been a lot of things that happened when Jason exercised his time with the children, and we have to come to another hearing on July 17th. As unfortunate as it was, Judge Christensen had to call the children because all the picture that Jason was trying to say about the children are they're lying on the therapy. So Judge Christensen had to call them, and they were interrogated by Mr. Jones' lawyer because I didn't have a lawyer, and the judge. And it was on that judgment that Mr. Jones was found not credible for his testimonies that he's been still harming the children verbally and then physically, and all the events that led up to that. GAL had done her reevaluation again and reassessment. So it was deemed by Judge Christensen that Jason is still a danger to the children and he can't have more time. And to follow up with Dr. B. George, after he only saw the children, he is the third or fourth therapist, April and May of 2022. And after he wrote that recommendation, when he saw the children last, he apologized to the children and he said, "I'm sorry that what is your father doing to your children?" Because he told this to the children, and you can confirm it if you will call my children to testify in court. And Dr. B. George apologized to them that this is the last time I'm going to see you, because their father had an altercation again with Dr. B. George. And he said, I just wrote that because he asked me to do so. And he said that, I'm so sorry, I did not know that your father is hurting your mother, and because the father is saying a different say so. But I'm not there. I'm not there. I know this could be a hearsay, so I don't want to say anything, because only the people that can testify on that. But based on,
Citadel Jones, I need to interrupt you for a second. Sorry, I just need to take a brief recess. I'll be back with you shortly.
I'm sorry, Your Honor.
Okay, sorry about that. Let's come back.
Oh, yes, Your Honor. If I may continue, I'd like.
Hold on.
I'm sorry.
I want to make sure Mr. Jones is back before you continue, ma'am.
I'm sorry.
All right, he's here. Go ahead, Ms. Citadel Jones.
Yes, if I may continue, Your Honor. When Dr. B. George saw the children, he's the third or fourth therapist, but he saw them April and May. He wrote the recommendation sometime in May. And then after that, he saw the children last, and he said he apologized to the children, and he apologized to them, according to the children, when they came home, that Dr. B. George is no longer their therapist, and he was apologizing to them, and he says, good luck. And he's sorry that he wrote that recommendation, because he knew, because he was asked to do that recommendation. And after that, he was never seen again. And Mr. Jones hired another reunification therapy by the name of Dr. James Iberg that they saw from June to July. And then August, it stopped again, because the last therapy with them, once again, the children witnessed Mr. Jones and the therapist had a back and forth. This is a pattern already that's been happening. That's why they kept on changing therapist after therapist. The children has not established a fundamental reunification relationship with the therapy and their father, because every time their father called them, my daughter and my son was very upset coming home, because their father always called them a liar and delusional, that your mother has put this in your head. That's why you became delusional and liars and making this up in your head, because I never hurt you once. I only loved you. I only loved your mother, and your mother is the crazy one. These are the words that my children are always coming home. And I don't know why, after the therapist would stop Mr. Jones and the children were upset, Mr. Jones, stop it. This is something that you need to discuss with your children. And my children would hear this. And after a while, I would get another text from Parenting Up. The kids have a new therapist. So, Your Honor, I'm not alienating the children. If something happens to them, they are going to their father. I wanted them to have a relationship with their father, but this is not about me. This is about Mr. Jones and the children, and during their therapy, because he's always telling the children that they're lying, the things that they have seen at the home growing up and that they witness, he's denying it, everything that's happening, and they're saying it's not true, it doesn't happen. That's why Judge Christensen, before, as much as she doesn't want to, she had called the children. My daughter testified for 5 hours. He's been talked by Jason's lawyer. My son stood in the court for last, and their stories were consistent according to the GAL. So, Your Honor, I would like to request, if they keep on asking for this, I'm doing as a mother, from what I'm hearing from my children when they come home, is to have the GAL reappointed again to reevaluate and reassess, because she's been in the case for 3 years since we started with Judge Christensen and other judges. But it was Judge Christensen who stayed long in the case, and she knows it very well, and the GAL, Kat Allen, knows it very well. So, Your Honor, it's not about me.
Ms. Jones, you have 1 minute to conclude your argument.
My argument, Your Honor, is respectfully, I apologize if I'm shaking. Respectfully, Your Honor, I'm just asking and request your honorable court. This is for the sake of the children. And this is based on when they come home, and this is based on there's no established and fundamental stability, even with the therapist that keeps changing by Mr. Jones. And from the stories of the children, in behalf of the children, Your Honor, before you grant them more unsupervised time, to reappoint the GAL to do more reevaluation and reassessment, and so she could speak with a trauma therapist of the children from a safe place. That's
Okay.
all, Your Honor.
Thank you, Ms. Citadel Jones. Is there any reply, Mr. Esser?
There is, Your Honor. What I would say, there's a lot to reply to. That some of these things that she's saying that were said in therapy, it's just simply not true. I spoke with Dr. Biorgi. He told me that the sessions were productive. He didn't say anything about, Jason telling the children that everything they said is lies. So we refute that completely. I do want to say Judge Christensen did hear testimony from the kids, and she found that she did believe that Ms. Jones was alienating the children. We do believe, and this goes to the motion that we just filed last week, that Ms. Jones is continuing to plant ideas in the children's head. And that's why I think we need to have a custody evaluator at this point appointed. But that motion is just for presented. All that today's motion is about, what I thought was going to be a simple motion, was to say he had been on supervised visitation for 1.5 years, that he had been doing the counseling, that we had been making progress, and that, for something simple like take the kids out for a dinner and a movie, that this would be a small first step to get him off supervised visitation. Supervised visitation shouldn't last forever. So, I was hoping that we would have some agreement on that. Ms. Jones and I have spoken even after last Tuesday's court date. We spoke again about, could there be some compromise here? There is not going to be any compromise. At some point, Mr. Jones needs to come off supervised visitation so that he can start to have a normal relationship with the kids again.
Okay, thank you. The last thing we need to deal with today is the July 1st petition for rule to show cause, filed by Ms. Citadel Jones, where she's asking me to order Mr. Jones to designate her as the payee for the Social Security benefits for child support. Ms. Citadel Jones, before you argue that, hang on one second. Do I have Marcia Reyes with me this morning?
Sure.
Yeah.
Yes, let me go in.
Okay, Ms. Reyes, can you hear me?
Yes.
All right, I see that you just joined us a minute ago. Court started at 9 today. Where have you been?
No, it did not let me go in. I was putting the wrong one in.
I didn't hear what you said.
I said I was putting the wrong one, the wrong one, the wrong password.
Did you call the clerk's office?
No, I don't got that phone number.
What have you been doing for the last 2.5 hours?
Huh? I
Okay.
was looking for the number on the how you call it, on the app, on the website.
Okay, well, court starts at 9, and I'm not sure why it took you 2.5 hours to join us, but since you weren't here when your case was called, I struck the motion that you filed. So if you wish to refile your motion, you can refile it, but since you weren't in court this morning, it no longer exists. You understand?
Okay.
All right, you're free to go. Thank you. Ms. Citadel Jones, you can make your argument now.
Your Honor, can I please drink a water first?
Sure.
Is that okay? Yes, Your Honor. Regarding with this Social Security benefits, on June 3rd of 2022, I noticed that the money that was directly deposited to my PNC bank account did not go through. So I contacted the Social Security hotline number, which I submitted to you, and I called them, but unfortunately I can only give my own Social Security because I'm the mother, and then I gave the Social Security of my children, so they were able to connect that indeed my children are receiving Social Security benefits. So they can pull up the record. I have to give my own Social Security first. And then they said that they had to stop the payment because the beneficiary and the payee is still Mr. Jason Jones. And they found out that the money, the bank that it's going to is Maria Citadel Jones, and I am not assigned as a designated payee, and there was no paperwork that was filed by Mr. Jones for me to be the payee. And they told me, I said, is there any way that I could send you the divorce paper? I was granted, and they said only Mr. Jones can and will be the one to take care of the paperwork himself. He can go to the local office and take care of it and assign you as the payee, and this will be taken care of. And if he takes care of it right now, your July payment will come in at the same time, and the June payment will be back paid to your account if Mr. Jones, the beneficiary, will take care of it. So I communicated it very well with Mr. Jones, contacted him, and he ignored me for a couple of days. And I notified him again. I notified his lawyer, Attorney Asser, via email. And then Mr. Jones gave me a reply, it's not my problem, it's your problem, take care of it. And until then, I told them, as much as I wanted to take care of it, even in the Social Security local office, I cannot. My hands are tied. You are the beneficiary, you are the payee, and you were ordered by the court that you need to take care of the paperwork, and it says there on the court judgment by Judge Christensen. And until now, Your Honor, nothing is done. And according to Mr. Esser, according to Jason Citadel, he signed a waiver already to Shama Parikh during the divorce to take care of the paperwork. I said, what Jason Jones signed for the waiver is for discovery, because he kept on denying that he's receiving benefits for the children, and he kept denying that he's receiving, that he has a bank account. It was for discovery, and finally, when he signed that waiver, is only for the lawyer to find out if he's indeed receiving benefits, and they found out. That's why he started paying only later. Years he's been taking it to himself until it was discovered. So that paperwork he signed is not to grant my lawyer to take care, to have me as the payee. It was Mr. Jones who's supposed to do it. Until now, Your Honor, it's been 4 months, from June, July, August, September, nothing has been done. And also, Your Honor, if I may add before I stop talking, in the judgment order also, for school expenses, he's supposed to give and share 50% of the children's expenses. I gave the receipts. Your Honor, as much as I have a work, my 2 children are growing up. They have expenses in school, and I have been communicating with Jason, and he's just ignoring me. I communicated this with Attorney Esser. I submitted the receipts. I asked respectfully about the Social Security. I don't know if they're just ignoring me or they don't want to choose to do it. But Your Honor, please help me find a way for this to be settled and for me not to be ignored when I give Jason a receipt. These are for his children. These are not for me. Our daughter is in high school. I told them they need a lot of things, and I provided it on my own or for myself without any child support. I work, Your Honor, but I'm still saving up because my payment for the mortgage is due on November 1st by PennyMac. And because of the inflation, they raised the interest from 4% to 6.75. So my mortgage that I'm going to pay is $2,397. And I only make around $3,800. So I'm taking a part-time job as a caregiver on a weekend to provide for my children. So I'm saving for the first mortgage payment on November. So you could only imagine, Your Honor, that if Jason at least cares for the children's welfare, this is not about me. This is not my expenses, Your Honor. These are for his children. This Jason Jones Jr. is 7th grade. Cherry Jones, freshman at Woodland. The TI-183 calculator alone, Your Honor, is $119. I'm sorry, Your Honor. I'm sorry.
That's fine. All right, Mr. Esser, response?
Yes, Your Honor, and I want to be, very polite and respectful, but what Ms. Jones is saying on a number of levels, it is out of touch with reality. So Mr. Jones has directed those payments to go to Ms. Jones. Mr. Jones, as ordered in the judgment, has signed a release that went to Ms. Jones and Ms. Jones's attorney so that they could get information. So she's able to contact Social Security. That's how she's able to get this information. Ms. Jones had been receiving at least 15 months of these payments. Mr. Jones is not receiving these payments. He's not the payee for these payments. So the question when Ms. Jones and I talk is, if you are still the payee, which she admitted to you she is, what is it that Social Security needs in order for these payments to get to Ms. Jones? Is it a bank account issue? Is it, what is the issue, right? And then we hear, as Your Honor heard today, all of these other things about the expenses for the children and Mr. Jones isn't paying. But what is the heart of this issue? If Ms. Jones is the payee and Mr. Jones is not receiving the money, and Social Security will give her all of this money, like once this gets all of the back pay, I just don't know what the issue is. And Ms. Jones and I are having a breakdown of communication because she's not able to express to me what the issue is. But above and beyond that, let me say, with this mortgage, Ms. Jones filed for bankruptcy, Your Honor. I don't understand why she's paying a mortgage that she's been relieved of. This also is out of touch with reality. So again, I think I've made my point, but Ms. Jones was not being ignored. The question is, what is it that needs to happen? My guess is that Social Security is attempting to make these payments and they don't have either her bank information. There must be some holdup on that end. Thank you.
Mr. Esser, you made a reference to back pay. I think you said something along the lines of you believe Social Security would start paying her as the payee if it wasn't for back pay. What's that a reference to?
So I'm hearing this from Ms. Jones, Your Honor, right? So Ms. Jones says that once whatever the problem is fixed, she will receive the payments that she's missed, quote unquote. She has been receiving these monthly payments from Social Security up until June. And something happened in June. And then as Ms. Jones and I have spoken, Ms. Jones says, as long as it gets fixed, then she'll get all the back pay. The problem is that I don't know what the problem is. I don't know what needs to be fixed to fix this issue.
Okay. Ms. Citadel Jones, I think you might have said this earlier, but are you designated as the payee for the Social Security benefits?
Not that I know of, no, Your Honor. Like what I stated on my first statement with you this morning, Social Security Office told me I'm not the designated payee because Jason Jones has not appointed me as the payee, and he needs to go to the local office to take care of it. And I have stated this, I've communicated with Mr.
Okay.
Jones. There's a receipt.
Hold on. So, Mr. Esser, I don't know if it's true or not, obviously, but Ms. Citadel Jones is saying that the information she's receiving is that she is not the designated payee. Now, you said that it is your belief and your client's belief that she is the designated payee. Is that correct?
That is our belief, yes. And we believe that from at least March of 21 up through May of 22, that she was receiving payments from Social Security on a monthly basis in fulfillment of, yes.
And has your client contacted the Social Security Office, Social Security Administration, whatever it's called, to confirm that Ms. Citadel Jones is in fact the designated payee?
I don't believe that. Yes, I don't believe that he has contacted them. No.
Okay. Mr. Jones, can you unmute yourself, please? Have you gotten in touch with the Social Security Office and confirmed with them that Ms. Citadel Jones is the, quote, designated payee? Okay. Is it your intention and belief that she should be the designated payee as it relates to these funds? Do you believe that she should be? I don't know if she is or not, listed as a designated payee, but if she's not, should she be? She's supposed to be receiving these Social Security benefits to use them for the benefit of your children. Is that correct? Okay. Which means she should be designated in whatever manner is necessary by the Social Security Administration as the payee or whatever they want to call it, so that she can receive these funds and use them for the children. Do I understand that correctly? Okay, fine. Okay. That's fine. So what I'm going to do is give you my rulings regarding these four motions and indicate how I'm going to handle Mr. Jones and Mr. Cubitt as well. So first, with regard to the first petition for rule to show cause that Ms. Citadel Jones filed, the parties were required, well, the language in the parties' order read as follows, open quote, the parties shall immediately sell the Kawasaki motorcycle for its fair market value, close quote. Now that was over a year ago, if I'm not mistaken, that was ordered. That has not been done yet. I'm sure there are many reasons that it hasn't been done yet. One is that Mr. Jones has possession of the motorcycle, and two is that Ms. Citadel Jones has possession of the title. And obviously you're not going to be, as I think Mr. Jones himself said, or maybe it was Mr. Esser, you're not going to be able to sell the vehicle for its fair market value without possession of the title to be able to present the title to the buyer. That probably explains why Mr. Jones has a buyer in place to buy this vehicle without Mr. Jones having possession of the title for the amount of $750, which is nowhere near the fair market value for the motorcycle. So what I'm going to order to resolve the petition for rule to show cause is this. Now, what I could do as a result of the petition for rule to show cause is find that Mr. Jones has not complied with the judgment order, which requires the parties to immediately sell the motorcycle for its fair market value, hold him in contempt of court, and sentence him to jail. But I'm not going to do that, at least not yet. What I'm going to do instead is I'm going to order Mr. Jones to turn over possession of the motorcycle to Ms. Citadel Jones within 7 days so that she can sell it for the fair market value. If Mr. Jones fails to turn over the motorcycle to the possession of Ms. Citadel Jones within 7 days, then I presume I'm going to have to see you in court again, because Ms. Citadel Jones is going to file a petition for rule to show cause, asking to hold Mr. Jones in contempt for failing to abide by my order. So what this means in English is you're ordered, Mr. Jones, within 7 days to turn over the motorcycle to Ms. Citadel Jones. She is then ordered to sell it for its fair market value, and you are both ordered to follow the judgment of dissolution of marriage. If Mr. Jones fails to turn over the vehicle to her within 7 days, upon motion, I will hold him in contempt of court, and I will sentence him to the Lake County Jail until he complies with the order. So Mr. Jones is ordered to turn over that vehicle within 7 days. Now, next, regarding the motion that has to do with the former residence, I understand that the parties have agreed, and I've spoken to Judge Christensen about this and the case in general. I understand the parties agreed that Ms. Citadel Jones was going to have 180 days from that October 3rd date to clear up the foreclosure proceedings. I understand the allegation that she has not been able to do that, which I believe she admitted to. And then Mr. Jones has another 180 days past that to clear up the foreclosure proceedings. And if he does that, he gets the house. I understand Mr. Esser and Mr. Jones are telling me that Mr. Jones's brother, I think it was, has the intention of clearing up the mortgage, and he's taken steps in that direction, but it has not yet been done. Now, Mr. Esser is asking me on Mr. Jones' behalf to order the turnover of the house. That request at this point is premature. Mr. Jones has not yet, at this moment, cleared up the mortgage foreclosure as is required by the court order. Since he hasn't done that yet, I can't order that the house be turned over to him at any point in time. So since this motion is premature, I'm going to deny it. And if we ever get to a point where the foreclosure is cleared up and everything else that's required in the judgment of dissolution and all other relevant orders has been met, you can file another motion if it's necessary to file another motion. Now, Mr. Esser made reference to the fact that a motion to modify or a petition to modify the judgment order or marital settlement agreement has not been filed. That's correct. Ms. Citadel Jones, to this point, has not filed a petition asking me or any other judge to modify what was in the agreed order. So since there is no request to modify it, I'm not going to modify it. And as it stands right now, the prerequisites in the judgment of dissolution that would allow Mr. Jones to get the house have not occurred. The motion is premature. It will be denied. Now, regarding the motion to modify parenting time and for unsupervised parenting time, I understand that those two witnesses, Mr. Jones wants to have those two witnesses testify today. I'm not going to take the testimony of those witnesses today because based on my reasoning, it's not necessary. And my reasoning is this, the letter that Mr. Jones relies upon from that doctor is more than 3 months old at this point, and it hasn't been updated. Now, there's several issues with the letter. One, it's not clear whether the doctor intended for the 5 hours to be over and above the 3.5 hours at church or not. Secondly, that doctor is not one of the approved therapists listed in the relevant court order, nor has the court received any evidence that the parties agreed that this gentleman would be an appropriate therapist, which is another way that his appropriateness can be determined pursuant to the judgment order. There's also a debate about whether this doctor's opinion would still be the same here today on September 9th that it was on May 24th, and this doctor is not here to testify to tell me that. Now, I would not change the parenting time, the unsupervised parenting time, without the testimony or evidence from an expert as it stands right now, which is why it's not necessary for me to take the testimony of Mr. Jones' brother or the other gentleman, because neither one of them is an expert. So their testimony would not convince me to grant this motion. So based on the information I have in front of me at this time, that motion is denied. Now, regarding the final motion, which is Ms. Citadel Jones' petition for rule to show cause, she's asking that Mr. Jones fill out the necessary paperwork to designate her as a payee or as the designated payee for Social Security purposes so that she can receive the money that she's supposed to receive from Social Security benefits. Now, everybody seems to agree that Ms. Citadel Jones should be receiving this money. Everybody seems to agree that she's not receiving this money. Now, the judgment order and the other relevant court orders require Mr. Jones to fill out the necessary paperwork in order to make sure that the Social Security benefits are received. So what I'm going to do regarding the petition for rule to show cause, again, I could grant the petition for rule to show cause and find that there was a willful failure to follow it and hold Mr. Jones in contempt of court and sentence him to jail until he does what he's supposed to do. However, just like I did on the last one, I'm not going to do that today. I'm going to give Mr. Jones a chance to repair the situation. So I'm going to issue the rule to show cause today, but I am not going to make a ruling on the question of contempt. I'm going to continue the case to our next court date to see whether Mr. Jones has complied with my order and did what he was required to do in order to make sure that Ms. Citadel Jones is the designated payee. So what I'm ordering is within 7 days, Mr. Jones is to get in touch with the Social Security Administration and assure that Ms. Citadel Jones is the designated payee for these benefits. I am sure that Mr. Jones is going to follow my court order and do this. If, however, Mr. Jones does not follow my court order and refuses to do this, then on the next court date, I will find him in contempt of court and sentence him to jail until he does this. Those are my rulings on these 4 motions. I will draw up a court order myself and sign it and send it to the parties. Now, the last thing that we need to deal with is there is a motion to modify parental responsibilities and to appoint a custody evaluator. I am going to give Ms. Citadel Jones time to respond to that in writing. I'm going to give her 28 days to do so. Oh, I'm sorry. Yeah, I'm going to give her 28 days to do so, and I'm going to set this matter for hearing on October 14th at 9 o'clock. Assuming that date works for Mr. Esser and Ms. Jones and Mr. Jones. Anybody have a problem with October 14th at 9?
It works for me, Your Honor.
Mr. Esser, does that date work?
October 14th at 9 works for me, yes.
That date work for you, Mr. Jones? Did you hear the question that I asked you, Mr. Jones? All right, I'll assume October 14th at 9 o'clock works fine. Mr. Jones continues to address the court out of turn, despite the fact that he has an attorney representing him. So I'm no longer going to respond to those comments. Anything else, Mr. Esser?
No, thank you, Your Honor.
All right, I will send the order and I'll see everybody on October 14th at 9 o'clock.